All right, first on the docket, I'm sure most people have heard by now the passing of the notorious RBG. That's right, Ruth Bader Ginsburg. She died of pancreatic cancer Friday evening. Big news, and let's do a quick recap of her life. If anyone has seen the movies regarding Ruth Bader Ginsburg, they are inspiring. And whether you agree with her politics or her analysis on the court, they're both worth watching. This woman is the epitome of never give up, and she changed the laws through the courts, not usually as a judge, but as an advocate, as a lawyer early in her career that benefits everyone today. So I would urge you to watch the movies On the Basis of Sex, which is a story of her life and the hurdles that she had to go through, as well as the documentary RBG. Obviously, Ruth Bader Ginsburg and the Notorious RBG is a play based upon a famous rapper, and she has become an icon, particularly to many people in America, including lots and lots of young women. And she was, like I said, whether you liked her or not in her opinions, her story is very impressive. And what is, I think, a great story about Ruth Bader Ginsburg on the court was that her best friend on the court was Anthony Scalia. Anthony Scalia and Ruth Bader Ginsburg probably did not agree on anything politically or, in most cases, how court cases should in fact be decided. But they were the best of friends because they had a love of opera. And the two of them, two people you would think that couldn't get along or have anything to talk about, became very close friends. And I think that that is a good example of what we need more of in the world. You can agree to disagree about issues, but you can still be civil and nice to one another. Now, as we said, Ruth Bader Ginsburg died Friday evening of pancreatic cancer. And of course, before the news was even really scrolling across, there was already talk about her replacement. And let's face it, several years ago, when Anthony Scalia died, Merrick Garland was nominated by President Obama, and the Republicans at the time said, we're not going to get him through the process of confirmation. The next president should do it. And all the Republicans said, let the next president do it. Well, guess what? Like what happens in politics all the time, the scenario flips. And of course, now all the Democrats are saying, let the next president decide on the pick. And the Republicans are saying, no, let it go through, let it go through. Now, the biggest distinction here was that at the time President Obama nominated Merrick Garland, he did not, or the Democrats did not have control of the Senate, which the Republicans do now. Now, let's face it, ladies and gentlemen, there is enough hypocrisy to go around for everyone on the political spectrum as it relates to this. That's politics. That's what's frustrating about politics. But you would think, right? That's why we like laws. That's why we like rule of law, so that everybody knows what the rules of the game are. And let's face it, whether you like it or not, if there's a nomination, the Senate can hold hearings and give consent, which is their legal obligation under the Constitution. A lot of people are saying the president shouldn't do that. Ruth Bader Ginsburg's dying wish was that let the next president pick my successor. Well, that's not the way it works. That's nice. It's political for sure. But let's face it, the Senate will receive a nomination, whether it gets selected and whether advice and consent is given and the new judge will be appointed. We'll just have to wait and see. It's all politics, ladies and gentlemen, from here on out. Try to do anything other than to dismiss it as simply politics is simply, it's like I've said before, intellectually dishonest. The Republicans have plenty of hypocrisy to go around, and the Democrats have a ton of hypocrisy to go around as well, just like the Republicans, because let's face it, it's politics, and that's just the way it is. Now, Ruth Bader Ginsburg started her career. She was obviously a great student in high school. She received a full scholarship to Cornell University in New York and ultimately While at Cornell, she met her future husband, Marty Ginsburg, on a blind date. Ginsburg gave birth to her daughter in July of 1955, 14 months before starting Harvard Law School, where she was one of only 9 women in her class of approximately 500 people. Now, while she was at law school, she's also raising a child, attending classes, helping her husband, who's diagnosed with testicular cancer at the time, and still ultimately being the top of her class. She did not graduate from Harvard. She ultimately had to transfer to Columbia because Marty was ahead of her to finish her studies. And if you watch the movie On the Basis of Sex, you will see the injustices that she had to experience. This is a woman who graduated in her top of her law school class. Now, today, even when I went to law school, started, 26, 7, 8 years ago, whatever it was, the class was probably 50% male, 50% female. But back in the 50s, that was unheard of. So Ruth Bader Ginsburg was a trailblazer, and then to literally graduate number 1 in her class. So despite her top grades at Columbia, no law firm in New York would actually hire her after graduation. She described it in her words was that she had struck out on 3 grounds. She was Jewish, she was a woman, and a mother. She described that the first would raise an eyebrow, the second, 2, the third made me indolably inadmissible, is what she described. And she began ultimately clerking as she began a clerkship for a federal judge in New York who hired her only after the law professor who recommended her promised that he would supply a male lawyer if Ginsburg did not work out. She then went straight into teaching full-time, and then in the early 70s, she was hired as the first tenured female law professor at Columbia. During her time that she was teaching, she would also take cases. She ultimately argued 6 cases before the United States Supreme Court, winning 5. Most of her cases had to do with discrimination of either males or females based simply upon their sex. And she argued successfully to the Supreme Court that those restrictions were not equal under the law. Ultimately, the Supreme Court, as well as lower courts, found that they were unconstitutional. In 1980, President Carter appointed Ginsburg to the U.S. Court of Appeals for the District of Columbia. When Justin Byron White announced his retirement in 1993, Ginsburg, who was at the age 60, was older than most nominees, was not necessarily regarded as a likely candidate for the opening. In 2013, President Clinton nominated her to be a United States Supreme Court justice, and in his remarks nominating her for the Supreme Court, Clinton called Ginsburg a centrist, a consensus builder, and a judge who can be called a liberal or a conservative. But during her 27 years on the Supreme Court, Ginsburg was consistently one of the most liberal justices on the conservative-leaning bench. Perhaps as a result, Ginsburg wrote relatively few major opinions. One notable exception came early in her tenure at the court when she authored the 1996 decision holding that the Virginia Military Institute's policy of admitting only men violated the Constitution's Equal Protection Clause, which requires that people in similar situations receive the same treatment. Now, it was Ginsburg's dissents and her ornamental collars, known as jabots, that she wore over her judicial robes on the day that her dissents were announced, for which she was arguably best known. In some dissents, Ginsburg explained she wrote in the hope that the other branches of government would take action immediately to grant the relief that the Supreme Court had denied, which obviously makes sense. The court is not a legislature, and therefore, if you want to change the law, Congress or the state legislators have to do that, not the courts. That's what defines Justice Ginsburg's theory, is that she believes that she could rewrite the laws to fit the situation of the day, whereas a more conservative justice would say, no, we have to interpret the law that's written, and if it's a poorly written law, it's not our job to fix it. You let the legislature do it. They're more likely to fix it if they don't like the decision from the court. So whether you agreed with Judge Ginsburg's politics or not, she lived a very impressive life. And where else but in America can a woman from very humble beginnings rise and sit on the United States Supreme Court? for 27 years. She got there because she was crazy smart, wicked smart, and she should be remembered. And after she has been laid to rest, the politics are going to get even more heated. But those rules come from the United States Constitution, not the wish lists of people on the other side. And like I said, unfortunately, there's enough hypocrisy to go around in all of the political parties on this issue. Lori Vallow's attorney is at it again. That's right, big sigh. Every time this guy files something, it simply never ceases to amaze me. What is he doing? It makes no sense whatsoever. So Mr. Means, on behalf of Lori Vallow, has filed a motion to change the venue of the case. Now, this is kind of a little more formal pleading than what he had filed before, but not really. And he doesn't expand on any other reasons, but once again, he wants the court to set a briefing schedule for arguments, etc. Now, the rules of Idaho criminal procedure are rather clear. He has 28 days in which to file the motions, and he needs to do that. Well, then he files a motion for the motion for transfer, and he does the same thing. He didn't really change the caption. He says, well, we want to transfer this, and we want this to be done for the convenience of the parties. And he also says that the cases will ultimately be joined, so he's concluding that they will be. You have to remember, though, that Chad Daybell's attorney, Mr. Pryor, has filed his objection to the prejudicial joinder, or the motion for joinder, as filed by the district attorney in the case. So Mr. Means files this motion saying, hey, the motion for transfer and for joinder is basically based upon the series of facts, which are all the same, the charges in this particular case, and the exact facts, series of facts alleged in the case are the same as it relates to Mr. Chad Daybell. I don't get this guy. I really don't get this guy, what he is doing, all right? One of the things, obviously, we wanted to be able to do when we started this program was to be able to explain to the world what goes on in criminal cases and why they're doing it. Pryor, the attorney for Chad Daybell, and whether you like him or not, he is doing everything right thus far, okay? No complaints about the representation that he's receiving at all. Lori Vallow's attorney, questionable at best. You know, it appears as though Mr. Means does not engage in the practice of criminal defense work on a regular basis, and I think that comes out. Now, here's all he had to do. He should have objected to the joinder. Even if he wanted the joinder, he should have objected. It's called creating appellate issues. And this guy just doesn't get it. It's not a good tactical decision. Even if tactically you think the cases will ultimately be joined and transferred to another jurisdiction, you oftentimes have to object to these things to preserve the record, because if you lose, you want to create as many appellate issues as possible. It's used in plea negotiation purposes. DA is going to say, hey, I can make this case go away, all the potential appellate issues. This guy, Mr. Means, is just not very good. Now, who knows? He may come around and surprise me, but at this point, literally everything he has done to this point has been wrong. We can talk about that more this evening when we go live. Breonna Taylor, that's right. The grand jury has met there in Louisville, Kentucky, and guess what? An indictment came down, but it's not what a lot of people were hoping for. It's not that far off from what I anticipated. As you know, you're never going to make everyone happy. A lot of people were hoping that all of the officers were going to be indicted. However, the prosecutors have to deal with facts. They can't go out there just to make a political statement. They have an ethical obligation only to make charges that they believe that they can prove beyond a reasonable doubt. And just because it's going to appease people that are threatening to burn down your city, that is not enough to sacrifice somebody to criminal charges just to make people happy. There has to be facts and there has to be evidence. So what did we learn today? The Attorney General, Daniel Cameron, said that his investigation determined that Jonathan Mattingly and Miles Cosgrove were justified in their actions, and they did announce themselves as police officers before the shooting. Now, Brett Hankinson, who's already been fired, not for the conduct related to Breonna Taylor, but his conduct of allowing suspects to get personal rides home in his car and then maybe asking for some sexual favors in advance. That's why he was fired. Well, he now faces 3 felony counts, and bail was set in the amount of $15,000. A warrant was also issued for his arrest. The mayor of Louisville has imposed a 72-hour curfew. The National Guard is on standby, and things are already building, let's just say building. And as we talked about the other day, the city of Louisville gave $12 million for a settlement to Breonna Taylor's family, which also included a host of police reforms that the family thought was appropriate. Now, we're going to put up the entire news conference of the Attorney General in this particular case because I think it is very relevant. It's important to see how he lays out all the facts for you to see. I didn't get the feeling as though he was hiding anything. He laid it all out there and said he's charging what he can prove. Now, as I stated, Brett Hankinson, the officer who's, I guess, actually a former police officer, he was indicted, but not for shooting Breonna Taylor. Brett Hankinson was fired back in June, and he was indicted, as we stated, on first-degree wanton endangerment. Wanton endangerment is a Class D felony, carries a penalty of between 1 to 5 years in prison. And it is alleged that Hankinson wantonly shot a gun into apartment 3, which is a separate apartment than the one that they were going into where Breonna Taylor was shot. Now, the occupants of those apartments were identified by initials. None of them were Breonna Taylor. That means the grand jury didn't find that Hankinson wantonly fired into her apartment. Now, the Kentucky Attorney General, Daniel Cameron, said at this press conference that the grand jury decided homicide charges are not applicable because the investigation showed that there was nothing conclusive to say that Hankinson's bullet hit Breonna Taylor. Attorney General Cameron said that Jonathan Mattingly and Miles Cosgrove, 2 of the 3 officers who fired their weapons the night that Taylor was killed, were justified in their actions, which prevents prosecutors from pursuing criminal charges. Obviously, right? There's no violation of the law. You can't prosecute somebody. The Attorney General, Mr. Cameron, stated that in his investigation, and this was kind of different from what the press was reporting, found that the officers at Taylor's apartment did in fact knock and announce that they were police officers before that shooting. That account was corroborated by independent witnesses, according to the Attorney General. That is significant. As you may recall, Breonna Taylor's family was rather persistent in saying that it was a no-knock raid and that the police never identified themselves, which is why Mr. Walker thought that it was a home invasion and fired at the police. But the Attorney General was rather clear and said this was not a no-knock warrant. None at all. Attorney General Cameron also stated that the FBI, who handled the ballistics test in this situation, determined that the fatal round was in fact fired by Officer Cosgrove. And the Kentucky State Police ballistics test wasn't able to determine who fired the fatal shot. Now, Cameron noted that there were several wounds that Miss Taylor received from the gunshot, but that only one was a fatal shot. The others would not have killed her. Federal authorities are still investigating to see if any federal laws have been violated, but nothing as of yet. Now, hopefully, the city of Louisville and other towns across the country will not see violence. There are going to be people that are upset. But I think that if you watch the entire interview from the Attorney General, Mr. Cameron, you will see the facts do not support a charge against the other officers. In a quick nutshell, what happened is police officers apparently go in after they knock. Mr. Walker, the boyfriend, thinks that there's an home invasion, shoots. The officers then return fire. The officers were justified under the law to engage and unfortunately kill Breonna Taylor, but they were legally justified to do so. Some people may not do that. Some people may not like that decision, but that is the law. But just remember, ladies and gentlemen, you can protest, you can march, but as soon as you hit another individual, as soon as you destroy or vandalize somebody else's property, that's criminal mischief. That's rioting. Please don't do anything like that. That is not justified under the law, and it's certainly not justified to tear up other people's things and destroy things just because you don't like the way a legal decision came down. Guess what? Today would have been Tylee Ryan's 18th birthday, and her family has set up a vigil for her. Obviously, instead of having a birthday, her friends have to have a vigil because she is no longer with us. And her family said that they wanted to remember and celebrate her for what she was, a strong, loving, beautiful young woman, according to Janice Summers, one of the vigil organizers. And her spirit is an example to all of us to love and care and protect anyone around us with everything we have. Now, obviously, everyone knows that Tylee and her 8-year-old brother, Joshua, J.J. Vallow, were found on Chad Daybell's property on June 9th of this year. Tylee and J.J.'s mother, Lori Vallow, has married Chad in November of last year. Now, for months, they refused to tell investigators where the children were, but now the police believe that Tylee was killed on or about September 9th, 2019, and that J.J. died September 23rd, 2019. So today, September 24th, would have been her 18th birthday. And as I stated, people that knew Tylee wanted to express their gratitude for every moment that they had with her and how they were blessed by having her in her life, according to Summer Shiflett, Tylee's aunt. Tylee's aunt said that she was a talented singer, dancer, artist, photographer, decorator, hairstylist, makeup artist, impersonator, and swimmer. She performed in school shows, and she exceeded at everything she tried to do. Obviously, that was cut short. Shiflett noted that Tylee had a great faith in God and said that she said the most beautiful prayers. At a balloon release program in Arizona meant to honor the children last month, Shiflett shared various things about her niece and her personality. Shiflett said that she had a heart of gold and that she would be there for any of her friends that needed her for anything. Now, a makeshift memorial in Tylee and JJ's memory was set up weeks ago across the street from Chad Daybell's home. Now, as you can see, lots of ribbons and bows and flowers and signs have shown up there, and the Rexburg Police Department detectives who have been working on the case have stopped by and paid respects just yesterday. Tylee's aunt wanted to thank the police because although they never met Tylee or JJ, they have devoted the last 10 months of their lives to making sure that justice will be served. Tylee's aunt stated that these men have seen things that cannot be unseen, and she prays that time will dark those memories for them. The vigil is actually set for 8 p.m. this evening at the Porter Park Pavilion in Rexburg. Wish we could be there as well, but certainly our thoughts and prayers go out for Tylee, JJ, and her family. Next on the docket, Suzanne Morphew's brother has come to town. That's right. Suzanne Morphew is the woman who was reported missing on Mother's Day, May 10th, after leaving her home, allegedly going on a bike ride. Well, Suzanne Morphew's brother, Mr. Andrew Mormon, has flown in from Indiana, and he will begin and organize a 5-day search in the mountainous areas where his sister was last seen. Their goal is to have 1,000 people that can fan out and search the areas and look for anything that would lead to something of evidentiary value regarding the disappearance of Suzanne Morphew. Now, Mr. Morphew doesn't believe that he expects to find his sister alive. He originally hoped that that would be the case, but given the fact that it has been such a long time since her disappearance, he sounds like, unfortunately, has given up hope. But his biggest fear is not finding anything at all. Now, the Chaffee County Sheriff's Department has stated that they can't lead the new search effort because of liability issues. You know, you can't have civilians around there on a government-organized search because if they did, They could sue the sheriff for not taking proper precautions, like, I don't know, putting up handrails when climbing down mountains and things like that. But, the lawyers ruin everything. Mr. Mormon has said that a search team found evidence near the Morphew residence on Thursday, but he couldn't go into specifics, and he said that the Colorado Bureau of Investigations, as well as the Sheriff's Department, were actually processing this new evidence. Mr. Mormon didn't want to get too excited about it and really didn't want to talk about it because it really could just be nothing. Barry Morphew, the husband of Suzanne Morphew, you would think would be out patrolling and assisting in the search, but according to Mr. Mormon, he said that he ran into his brother-in-law yesterday when they were apparently crossing paths on the mountain, and we found evidence that he was out hanging trail cams, and he had a shotgun on his shoulder and warned us not to go any further because they were about to enter onto his private property. So it doesn't sound like Barry Morphew is going to be participating in the search for his wife. It could just be because maybe there's a family disagreement, or it could also be that maybe he knows that there's nothing to go search for. We don't really know, but obviously we give everyone the presumption of innocence until and if they are found guilty or plead guilty in a court of law. Now, Mr. Mormon has his own theories, and he believes that his sister was in fact abducted. He doesn't think that she ever got on her bike, and he speculates that she died probably Saturday and that she was hidden away somewhere Saturday night. Mr. Mormon further went on to say that this was in fact domestic abuse. Mr. Mormon, and there's a lot of other YouTube channels out there, you have to be careful. You cannot go around accusing people of serious crimes and not expect some sort of repercussions if, in fact, you're wrong. Now, we obviously give everyone the presumption of innocence, and we talk about the facts. We try not to get into theories that cannot be supported by the facts. And there's a lot of people out there, particularly on YouTube, that are saying lots of things that could result in someone getting sued. And let me give you an example of what that could look like. Remember this guy? That's right. He's one of the Louisville Police Department officers, Sergeant Jonathan Mattingly. Well, guess what? He intends to file civil lawsuits against those who have called him a murderer for his role in a fatal shooting of Breonna Taylor. Imagine that, ladies and gentlemen. Now, Mr. Todd McMurtry is representing Officer Mattingly, and he put up a video that shows Officer Mattingly being driven away in the truck bed after he was shot at Breonna Taylor's apartment on March 13th. And he says they called him a murderer when all he did was defend himself. Well, guess what? The Courier-Journal, Mr. McMurray sent them a letter stating, "We represent Mr. Mattingly, and guess what? With regard to affirmative claims he has against people who called him a murderer, these statements are defamatory and actionable." He said that the intent was to file civil lawsuits related to those statements. So, ladies and gentlemen, newspapers, the TV reporters, the talking heads may get up there and state that they think somebody has done something wrong. Guess what? These people that say these types of things without being able to back it up and say that here are the charges, here's a conviction, you face defamation suits. You better be right. And I know a lot of people like to maybe they get a little too far over their skis when it comes to these things because they get excited and they get emotional, but you could really be facing civil action against you for these statements. These people are not public figures in the sense of the fact that they are not politicians. They are not actors. It is a much lower standard of proof. So if someone can be represented by an attorney such as Lynn Wood, who wins a lot of cases as it relates to defamation, and I assure you those cases probably are settling in the high 6 and low 7 figure marks. So people, be careful out there. Choose your words wisely.